Good evening and welcome to the fourth and final installment of the ALL Get the Facts webinar series on the 2016 Gender Equality Referendum. Lisa Benjamin will present on Bill number 4, and this bill seeks to ensure that no one can be discriminated against whether they're man or woman. You can join the Google Hangout by emailing activeleadershipleague@gmail.com, or you can view the webinar series on the Active Liberal League YouTube page. So to get right into it, Lisa Benjamin is an assistant professor at the College of the Bahamas, where she teaches international and Caribbean environmental law, international trade law, intellectual property, and company law. She completed her BA at McGill University, her LL.B degree at the University College London, and her LL.M at the University of London. She's a PhD candidate at the University of, I don't know how to pronounce this word, Leicester. She's the founder of the Environmental Law Clinic, a co-founder of the Climate Change Initiative at the College of the Bahamas, a member of the Bahamas Trade Commission, and the director of the Bahamas Protected Areas Fund. Since 2008, her research agenda focuses on the role of law in development, including gender policy issues. Lisa is also a proud member of the Active Liberal League. Give it up, y'all! Lisa Benjamin is about to do the thing.
Good evening, everyone, and I'd like to thank all ALL for inviting me to speak with you this evening. And I'm very pleased to be able to discuss with you Bill 4 of the Constitution. So I am just going to get my slides up so that you can see them. And hopefully they are up now. Mm-hmm. So I'm going to talk generally a little bit about the Constitution itself and why this referendum is so important, and then I'm going to get right into Bill 4.
Does she show it?
I'm going to also address some of the controversy around Bill 4 in relation the relationship between Bill 4 and same-sex marriage. And then I want to talk a little bit about the international context of gender equality and connect the issue of inequality to violence, and particularly violence in the Bahamas. So if I talk just a little bit about the Constitution itself, we are a constitutional democracy, which means that our entire state was established through this written Constitution. And as a result, the Constitution is divided into what we call different chapters, and underneath each chapter is an article. So I will be referring to specific articles in relation to Bill 4, but the Constitution has many different chapters to it, including Chapter 2, which deals with citizenship, which are Bills 1 through 3, and Bill 4 affects what's called Chapter 3 of the Constitution. And Chapter 3 covers the protection of fundamental rights and freedoms of the individual. And the reason why we need a referendum to deal with amending any part of Chapter 3 is that certain provisions of our Constitution are what they call entrenched. And entrenched provisions of the Constitution require a public referendum in order to change the Constitution because they are deemed to be that important. So this constitutional referendum is very different than the referendum that was held on gambling. For the gambling referendum, they actually didn't need a public referendum in order to change the law. But for Bills 1 through 4, they actually do need a constitutional referendum to change the Constitution. And it's different in that if 51% or more of the population vote yes for any of the 4 bills, the government is required by the Constitution itself to actually change the Constitution. And so a majority decision of yes is an obligation on the government to actually do something. If the vote is no, then the government does not have to do anything, and in fact cannot do anything to the provisions in the Constitution that these bills are designed to change. The last thing I want to say is that all 4 bills stand on their own. That means if the majority voted yes to, let's say, 2, 3, and 4, but no to 1, then that means that changes would be made on the basis of bills 2, 3, and 4, but no changes made on bill 1. So they are individual. I want to clearly state at the beginning that this is my view on Bill 4. I've looked at the Constitution, I've looked at the bill, I've thought about it, I've read other cases around it, and my view is that Bill 4 only deals with equality between men and women. It really doesn't deal with anything else. And so what do I mean when I talk about inequality between men and women? I mean examples like disparities in salaries for equal work. So for example, women are often paid less than men even when they do equal work. You can also see workplace segregation. So an example is BEC, the Heinlein workers at BEC. Those positions are offered to men and not to women. Another example would be, for example, men do not get paternity leave when they have children, whereas women do. I also want to very clearly point out the connection, which I'll do later in the presentation, about the connection between gender inequality and violence. And gender inequality is often seen in the lack of representation, particularly of women as politicians or at sort of the upper echelons of government for economic decision making. So let's dive straight into what Bill 4 itself says. On the slide in front of you, you should be able to see on the left what Article 26.3 of Chapter 3 says at the moment, today. And on the right-hand side of the screen, you should see the change that Bill 4 will make to Article 26.3 as well as Article 26.11. So just to give you some general background, constitutions are designed in different ways. And so some constitutions have what's called a general equality clause that says everybody is equal before the law. Some of them have a general equality clause and then say, for example, these are the areas that you shouldn't discriminate against. And we are in that third category, which only says specific ways in which people should be treated equally. And we do that through the definition of discriminatory, which you find in Article 26.3. So 26.3 defines discriminatory as affording different treatment to different persons attributable wholly or mainly to their respective descriptions. And then the language in bold is what's going to change with Bill 4. So the way that the descriptions for the definition of discriminatory work is if you are described by race, place of origin, political opinions, color, or creed, and you are affected by some kind of restriction or disability which is attributable to that quality of yourself, then that is discriminatory and it is prohibited in the Constitution. What Bill 4 will do is add to the description of race, place of origin, political opinions, color, creed, and it will add or sex. And so it will add to the definition of discriminatory if you are described mainly or wholly by sex. What Bill 4 will also do is add a new article in Chapter 3, which will be Article 26.11. And it will say in this chapter that defines the fundamental protections of individuals, sex will mean being male or female. So Bill 4 actually has two changes within it. One is to add sex to the description of how you can be discriminated against. And the second change is to add a definition of sex, being male or female, within Article 26. What Bill 4 would do is prevent Parliament enacting any laws which discriminate between men and women because sex is defined as male or female. And so what it does is enshrine what we call basic equality between the sexes within our highest or supreme law, which is the Constitution. I want to make it very clear that Article 26.1 and 26.2 say that this change in Bill 4 was not going to impact your private life or your household. So for example, if the man is the head of the household or the woman is the head of the household within your private home, Bill 4 will not affect that because Article 26.1 and 2 says that Article 26 only prevents discrimination in the passing of laws or the running of public authorities or public office. And so if Bill 4 passed, it would only prevent discrimination on the basis of sex, being discrimination between men or women, within the law or within any type of public services. What Bill 4 does not do, because we don't have a constitution that's designed like that, is it does not create a general equality clause. So as I said earlier, the way our Constitution and our discrimination definition works is it's very specific. It says discrimination on the basis of A, B, C, and D. It does not, our Constitution does not have, and it will not have if Bill 4 passes, a general anti-discrimination provision for everyone. And so that means that if Bill 4 passed, Article 26 would still not prohibit discrimination on some kinds of classes of people. So, for example, the disabled would not benefit from an anti-discrimination provision in the Constitution. Anyone in relation to their sexual orientation would not be able to benefit from anti-discrimination provisions in Article 26. So Article 26.4 at the moment is very specific, and the bill itself will only add one more specific category to that very closed list of persons who cannot be discriminated against. So I want now, having gone through Bill 4, to address the controversy that has evolved in relation to same-sex marriage. Same-sex marriage itself is currently illegal in the Bahamas under a very old piece of legislation called the Matrimonial Causes Act. That was passed in 1879. Before the Constitution, and it says under Section 21(1)(c) that a marriage is void, which means that it is not valid, it does not have any legal validity, unless it is between a male and a female. And so at the moment it is illegal for a male and a male, or a female and a female, to get married in the Bahamas. And my view, having read Article 26 in its entirety as well as Bill 4, is that if Bill 4 passed, it would still not lead to same-sex marriage for 4 different reasons, and this is my opinion. The first reason is that Bill 4 actually talks about sex being added to that list of criteria. It does not say sexual orientation. So, for example, Bill 4 does not say no discrimination on the basis of sex and sexual orientation. The reason I believe that it would not lead to same-sex marriage is from a case called MacDonald and Advocate General for Scotland, which was passed in the House of Lords in 2003 in England. And that very high-level decision clearly said that when you use sex, it does not include sexual orientation. And so according to the law, the term sex does not include sexual orientation. So that's the first reason I think it won't lead to same-sex marriage in the Bahamas. The second reason is that we clearly within the Constitution through Bill 4 define sex as male and female. And male and female is a sexual biological characteristic primarily. It does not include, defining it that way, sexual orientation. The third reason I think it won't lead to same-sex marriage is that the Constitution has what's called within it in Clause 40 something called the Savings Clause. And what the Savings Clause does is it effectively saves old law. And by old law, I mean any law that predates the Constitution. So any old law that was passed before the Constitution is saved in that anything in the Constitution does not affect it. The reason you have a savings clause in a Constitution is to ensure that the law continues in a cohesive manner. And if you remember, the Matrimonial Causes Act was 1879, and so it is old law and predates the Constitution. Now that is a complicated legal provision, but in my view it would save the Matrimonial Causes Act. The fourth and final, and I think the strongest reason why it will not lead to same-sex marriage is that the Constitution itself, in Article 26(4)(c), allows the government to discriminate. We call it the permissive discrimination provision. This is a clause which is equal to, on equal footing with, the anti-discrimination definition. And Article 26(4)(c) clearly says that the government, whatever you put in Article 26, whatever you put in the anti-discrimination provision, the government is allowed to continue to discriminate in what we call personal laws. And these are things like marriage. So Article 26(4)(c) says that whatever you put in the anti-discrimination provision, so whatever we changed Article 26(3) to say, the government is still allowed to discriminate in areas like burial, adoption, inheritance of property, and marriage. And so, for example, in the Constitution, we have protection for freedom of religion. But it still means that you can have burial grounds or cemeteries which are separate. So you could have a Baptist cemetery, you could have a Jewish cemetery, you could have a Catholic cemetery. That is discrimination in the area of burial. And the reason you can do that is because Article 26(4)(c) allows the government to discriminate. The same thing would apply for marriage. Article 26(4)(c) clearly says that the government can still discriminate in the area of marriage. And so the Matrimonial Causes Act, which says that marriage is void unless it's between a man and a female, would still be valid, even if you included sex within Article 26. And I feel so strongly about the clarity of Article 26(4)(c) that I think even if you included sexual orientation in the discrimination provision, in that list of categories, you could still discriminate in the area of marriage and still prevent same-sex marriage, because Article 26(4)(c) is very clear. Just to clarify, Bill 4 is not including sexual orientation in Article 26. It is only including sex. So having covered the same-sex marriage issue, I want to move on to look at the international context of gender equality. And the reason I want to look at this is because there's a number of international conventions that we have signed on to that tell us that gender equality is extremely important. Beginning with, at the very top, you can see the Universal Declaration of Human Rights, which was passed in 1948. This is almost every country in the world has signed on to this, and it really spurred on a number of other binding conventions, which include within it anti-discrimination provisions on the basis of gender. And these include particularly things that you can see on the top right, a convention called CEDAW. CEDAW is short for the Convention for the Elimination of All Forms of Discrimination Against Women, and this is a particularly important convention for the Bahamas. And I want to look at just very briefly what a couple of these conventions say. So for example, the United Nations Declaration on Human Rights at the very top in Article 2 says that everyone's entitled to rights and freedoms, and there should be no distinction, by which they mean discrimination, on the basis of things like race, color, sex, language, religion, political or other opinion. So as you can see, all the way back from 1948, non-discrimination on the basis of sex has been a very old principle within international law. So you can see that the language in bold is pretty much everything that we have in our Article 26 except for sex. And Bill 4 is designed to include sex within Article 26. In addition, CEDAW, which is a Convention for the Elimination of Discrimination Against Women, was passed in 1979. The Bahamas became a member and ratified it in 1993. And CEDAW clearly says that states, when they sign on to and ratify it, agree to eliminate discrimination against women within their national laws. We are a party to this convention, and therefore Bill 4 is very much in line with our international obligations. The final set of global agreements that I want to look at is what we call the post-2015 Sustainable Development Agenda, otherwise known as the Sustainable Development Goals. You can see on the right-hand side of the screen that there are 17 goals that the world came together and agreed in September 2015, and the Bahamas was one of those countries. We agreed to, for example, eliminate poverty, and Goal 5, which is the one I want to focus on, is the world agreed to achieve gender equality and empower all women and girls. So this is a very recent United Nations declaration, and we were very much a part of the negotiations and agreed to these goals, including gender equality. I want to say very clearly that there is no United Nations agreement approving same-sex marriage. The reason I say that is you often hear people say there's a United Nations agenda. The United Nations agenda is clearly focused, as I hope I've demonstrated, on gender equality. There is no agreement, convention, or treaty approving same-sex marriage at the United Nations, and the reason why I think is fairly self-explanatory. The United Nations is a group of a number of very diverse states. Included within those states are very conservative states. If you think of the Arab states or some of the African states or even some of the Caribbean states, they would never agree to an international agreement approving same-sex marriage. And so that's why there is none at the United Nations. And finally, I want to get into the very end of my presentation at the reason why I think that Bill 4 is important, particularly in relation to the connection between gender inequality and violence. The reason why the international United Nations and other conventions have stressed the importance of gender equality is that the United Nations and the international community believe that gender equality is not only important as a fundamental human right, but it's also important if we want to live in a peaceful, prosperous, and sustainable world. And I want to focus on the peaceful element of that. Gender equality is seen to be important in the international community because it really is the precursor towards sustainable development. And I want to look very briefly at our domestic context. The Bahamas, as we all know, is a very violent place. So there are some statistics on the slides in front of you. So for example, in the recent 4 years, there were a documented 9,000 incidences of assault against women. Between 2003 and 2013, there were over 1,000 reported rapes, and bear in mind that rape is one of the most underreported crimes. Rapes are actually on the increase in 2015 by 16% compared to 2014. Among 9 Caribbean countries, and the Bahamas was one of them, almost half of adolescent girls said that their sexual initiation was either forced or somewhat forced. There is no legislation which makes marital rape illegal, and in some research I did with a colleague, we found that women are primarily seen as vindictive. And we are one of the top countries in the world for gender-based violence. So for example, if we look at the Caribbean, the worldwide average of rape is 15 per 100,000 people, and we are at the top of the list in the Caribbean at 133 per 100,000. Gender-based violence is clearly a problem in the country, and according to some research done by COB in the Crisis Center, it's not getting better among our young people. In a survey that was done in 2014 of 15 to 18-year-olds, over half of the males surveyed and a third of the females said that men should discipline their female partner. So violence is seen to be normal and, in fact, acceptable within a relationship in the Bahamas. Almost half of men and 16% of women said that wives should have sex with their husbands whenever he wants to. Over half of boys indicated that their girlfriend had called them names, and a third of boys indicated that their girlfriends had been physically abusive by hitting or slapping them. 16% of men and 7% of females thought that a woman who dresses too sexy should actually be hit by her partner. So it's clear that violence is still an acceptable violence between men and women, and by that I mean gender-based violence is still an acceptable part of Bahamian society. And a very recent report by the Gender-Based Violence Task Force, which was published in August of last year, borrowed and supported this provision of another international convention, which I didn't have time to cover, called the Belém do Pará Convention. And that convention clearly says that gender-based violence is based on, and so it is fueled by, unequal power relations between men and women. And so the general problems of violence in our society, in my view, just cannot be cured without us addressing gender-based violence. And in order to address gender-based violence, ensuring equality within the law between men and males and females is a first step to address gender-based violence. And the strategic plan that was agreed by the Gender-Based Task Force supports that conclusion. We do need more domestic data to look at the connection between inequality and gender-based violence, but it is an acceptable connection both internationally and domestically within the Bahamas. And so I can't really tell you how to vote for Bill 4. It's entirely up to you when you go into the ballot box. But I do want to make the point that there is a connection between inequality within the law, inequality and traditional and stereotypical gender roles within society, and gender-based violence. And so for me, I think Bill 4 is an opportunity to really start to address gender-based violence in our society by ensuring that the law supports gender equality through the Constitution. That is it. Thank you very much.
Okay, thank you, Lisa, for that wonderfully clear and concise presentation. I think it was pretty clear, and what I'm going to do is I'm just basically going to ask, I think I have two questions that I commonly hear people ask or mention when it comes to talk shows on the issue of Bill number 4. So one of them is I commonly hear people say, well, if this bill passes, what is it? What is there to stop a man from going and challenging the ruling and saying that he's being discriminated against on the basis of being a man and him wanting to marry another man? What is there to stop him from making that claim?
So there's never a barrier to someone taking a case to court. Anyone can bring a case to court, and they could do so on the grounds that you're talking about, in that they feel that if Bill 4 passed, that they're being discriminated against on the basis that they are a male. However, my view is, and this is supported, for example, most recently, Michael Barnett, the previous Chief Justice, said that anyone can bring a case to court, but the Constitution is pretty clear that whatever you have in that discrimination provision, the government is still allowed to discriminate on the basis of marriage. And the government does discriminate on the basis of marriage in the marital, discriminates on the basis of sexual orientation in the Marital Causes Act. And so even if that case was brought, I think it's a more complicated argument because it's a two-step process. But what you have to say is that step one is that the Marital Causes Act says that marriage is void, unless it's between a male and a female. And step two is that Article 26 allows, in particular Article 26(4) says that the government can discriminate and is allowed to continue to discriminate on the basis of that. So sure, anyone can bring a case to court, but I really don't think that that would be a successful case at all, because the Constitution clearly allows the government to discriminate.
Okay, and what about when they, let's say, they take it to the Privy Council, because they mentioned that as well. If they don't get the result that they would like in the Bahamian courts, then they would just go to the Privy Council, and what would stop the Privy Council from then ruling in their favor?
On which they're making the decision. So, for example, they would have to look at our Constitution and go through the two-step process I've already done. Marital Causes Act says marriage is void, and number two, that the Constitution allows the government to discriminate. And again, I think it's important to note, in addition to that Article 26(4), as I've already explained, that Bill 4 is including sex, not sexual orientation, into the Constitution. And there's already a UK House of Lords decision that says that when you look at the word sex, it does not include sexual orientation. The Privy Council is effectively the House of Lords sitting under a different name. So there's already a House of Lords decision at that level that says that sex does not include sexual orientation. And so I think for those reasons, the Privy Council would not allow same-sex marriage to be legal in the Bahamas if Bill 4 passed. I think it's also important to note that all of the other international agreements that I've looked at deal with discrimination on the basis of sex. No country that I know of has ever been able to rely on that language of sex to bring in the legalization of same-sex marriage. And in fact, within the Commonwealth countries that have the discrimination provision that says no discrimination on the basis of sex, they have also not successfully ever been able to legalize same-sex marriage by using that language in the discrimination provision of a constitution. So I think I'm in very good company with the former Chief Justice when I say that, sure, anyone could bring it to court. They could appeal all the way up to the Privy Council. But I think it's pretty clear that the Matrimonial Clauses Act defines marriage as between a male and a female, and Bill 4 would not change that.
Okay, thank you so much. And also, again, I know you spoke about it earlier, but another thing I constantly hear people bring up is that the international agreements like CEDAW and other agreements that we've signed on to are forcing us to make these, like, things like same-sex marriage legal. Like, I know that's not the case here, but people seem to believe that the international bodies are forcing us to make same-sex marriage legal. So can you just reiterate that and dispel that notion for people once again for me, please?
Is the Convention for the Elimination of Discrimination Against Women, and it deals with women's rights. And we have been a party to that since 1993. We are actually in violation of that by not changing our Constitution and other laws. But, I mean, nothing's happened in 20 years. It's not like they come down and make you change your laws if you're in violation of a convention. You're not supposed to be, but it happens. In addition, CEDAW has no provision which deals with same-sex marriage. It does not, it doesn't cover that at all. And in fact, as I said previously, no United Nations agreement approves or encourages same-sex marriage. None of them do that, and the reason I gave before is because there's a number of very conservative countries within the United Nations who would never approve of that. Law is not like osmosis. It's not like a virus that you get, and so just because the United States and certain states has federally has legalized same-sex marriage doesn't mean that we're going to have to do it here. We are a sovereign country, and as I said at the beginning, our sovereign state was established through our Constitution. We're a constitutional democracy, so we are governed by whatever we put into the Constitution, and the Constitution already allows us, and has for 40 years, allowed the government to discriminate in certain areas. There are additional areas like lotteries and gaming, but personal law is the area that impacts the ability of the government to make sure that same-sex marriage is illegal, and it will continue to be illegal if Bill 4 is passed.
Hi, Lisa. I had a question. So suppose, and this is a question that I've heard from other people, suppose a gay couple were to be married in another jurisdiction, so say that they were legally married in the States, where gay marriage is legal, and they were to come here to the Bahamas and want their marriage to be recognized here. Would this Bill 4 allow that to happen?
No, it would not. The Marital Clauses Act, every jurisdiction has the national sovereignty to recognize whatever they deem to be marriage. And so the Marital Clauses Act has clear provisions that say that a marriage is void if it's not between a male and a female. And so that could mean that you could legitimately and legally get married in the United States, but once you come here, that marriage is void. And void means that it has no legal effect at all. So the Marital Clauses Act is very clear. It uses the language void. That also means you could go through a personal ceremony if you wanted to, but it's not a legal marriage.
Thank you.
Thank you so much, Lisa. This is one of the bills that has really encouraged a lot of discussions and emotions. And me personally, I've actually kind of had to learn how to stop debating once the debate turns from facts to feelings and then to just fear. But thank you so much for giving us that information, some of which, even after all our discussions and research, we haven't yet found. Thank you very much for coming to us tonight. Take care.
Thank you. What I would do is I would encourage people to actually read the bills and read the Constitution, particularly the article that I pointed out, which, just to tell you again, is Article 26(4)(c). So you can read the bill, Constitution itself, to read that. And the difficulty is that the Constitution is not easy to read. I'm a lawyer, and I still have to reread it several times. It was not designed for the ordinary person to read, which is unfortunate. And you know, we don't teach the Constitution in high school here, and so this is probably one of the first times, other than perhaps 2002, where Bahamians have had to engage with their Constitution. And I would encourage you to actually read it, have a look at it, and see what's in it. It's the foundational document of our country, and so if you are concerned or afraid, have a look at Article 26(4)(c) and read it for yourself and make up your own mind in relation to Bill 4.
Thank you, and good night.
Thank you and good night.